Hello friends, in this session I will be discussing with you the topic judicial activism through public interest litigation. In this session we will examine the meaning of judicial activism, trace the development of judicial activism in India and examine the procedural innovation done by judiciary to give relief to people. As the famous saying of Lord Howard CJ goes, it is of fundamental importance that justice should not only be done, but should manifestly and undoubtedly be seen to be done. It is from this concept that judicial activism has emerged and found expression through the judgments of activist judges. They have taken justice to the doorsteps of the citizen by stretching the letter of the law a little and acting according to the spirit behind it. The judiciary has intervened in cases where, due to blatant misuse of power or corruption or other antisocial elements in society, people have suffered. In judicial activism, judges assume a role as independent policy makers or independent trustees on behalf of society that goes beyond their traditional role as interpreter of the constitution and law. Near collapse of the government, judicial enthusiasm to participate in social reform, legislative vacuum, role of judiciary as guardian of fundamental rights and interpreter of constitution, public confidence in the judiciary are some of the reasons which compel a court or a judge to be active. For evaluation of judicial activism, there are basically two theories. First, according to theory of the vacuum filling, the vacuum is created by the inactivity, incompetence, disregard of law, corruption, indiscipline within legislature and the executive, and the judiciary is left with no other alternative but to expand its horizon and fill up the vacuums. The second theory of social want, which states that judicial activism emerged due to the failure of the existing legislation to cope up with the existing situation and problems in the country. Now let us look at the history of development of judicial activism in India. Prior to 1970, the view that existed among the common masses was that Parliament is sovereign body and can override not only the executive vis-a-vis the judiciary, but also the constitution. However, it was in the twin cases of Menka Gandhi in 1978 and Keshwananda Bharati in 1973, the judiciary formulated new interpretations of law, upholding constitution as the supreme law of the land. It was in the case of Keshwananda Bharati, the Supreme Court rightly rejected the stance that Parliament is sovereign and also formulated the doctrine of basic structure, which formed an impenetrable structure against all whimsical actions of executive or legislature. After these developments, the poor and the helpless sections of the society started looking towards the proactive judiciary for relief. Not only that, the NGOs, the advocates and other people started coming forward pro bono publico, and the judiciary has always been very cooperative in devising new rights as part of the basic human rights. The two most prominent figures whose names are the most interrelated with judicial activism and birth of PILs from mid 1970s to early 1980s were Justice P.N. Bhagwati and Justice V.R. Krishna Iyer. The public interest litigation or social interest litigation has become the most convenient vehicle for bringing public grievances before courts and one of the modes for judicial activism. Origin of public interest litigation has involved a number of things: the modifying the traditional requirement of locus standi, liberalizing the procedure to file writ petition, creating or expanding fundamental rights, overcoming evidentiary problems and evolving innovative remedies. Firstly, in the public interest litigation, the courts have relaxed the requirement of locus standi, where the constitutional or legal rights of a person have been violated and due to social or economic condition they are unable to approach the court for judicial redress. Any public spirited citizen can move the court for the public cause by filing a petition in the Supreme Court under Article 32 or High Court under Article 226 of the Constitution. It is not necessary that the person filing a case should have a direct interest or involvement in the matter of litigation. Like, a person in Mumbai can file a public interest litigation for malnourishment deaths in Orissa or protection of environment in Tamil Nadu. The PIL can be filed against agencies, departments and constituted bodies of state and central government, but not private parties and non-government organizations or institutions. However, a private party can be included in the PIL as a respondent after making the concerned state authority a party. As in the case of a private factory in Delhi causing pollution, people living in its vicinity or any other person can file a PIL against the Government of India, the State Pollution Control Board, making the private factory a respondent. Besides liberalizing the rule of locus standi, the courts have also taken suo motu cognizance of matter and initiated proceedings on the basis of letters, reports, and this has come to be described as epistolary jurisdiction. It is a special power of High Courts and the Supreme Court to initiate a hearing by itself without anybody filing writ petition when court feels that the matter requires serious and immediate legal intervention. Since public interest litigation is filed straight away at the level of Supreme Court or High Court, the parties do not have a meaningful opportunity to present evidence on record before the start of the court proceedings. To overcome this problem, our courts have developed the practice of appointing fact-finding commissions on case-to-case basis. In matters involving complex legal consideration, the courts have seek the services of senior counsels by appointing them as amicus curiae on case-to-case basis. The courts in writ petitions have formulated many new remedies for the people. The PIL have also witnessed the award of compensation by the courts to victims of human right violation, custodial death and many such cases. The court has explained that the award of compensation for established infringement of the most important rights guaranteed under the Article 21 is a remedy available in public law. Since the purpose of public law is not only to civilize public power, but also to assure the citizens that they live under a legal system wherein their rights and interests shall be protected and preserved. Some of the strategic areas where PIL's impact has been seen are protection of human rights of the vulnerable, economic, social and cultural rights, multifarious issue relating to environmental degradation, police accountability, accountability of public authorities as well. However, now the use of PIL in India has reached to such a stage wherein it has started undermining the very purpose for which PIL was introduced, leaving with the question whether PIL is a boon or a bane. PIL is now being used for frivolous issues also. The overuse of PIL has diluted the original commitment to use this remedy only for enforcing human rights of the victimized and the disadvantaged groups. In other words, the dark side is slowly moving to overshadow the bright side of the PIL project. Judiciary is often unable to ensure that its guidelines or directions in PIL cases are complied with. There are a lot of allegations raised against PIL on various grounds, which include over-extensive reliance on court-appointed commissions of inquiry. The problem of backlogs and delay remain a serious concern. The courts are being criticized for exceeding their institutional capacity and reversing constitutional priorities, usurping both legislative and administrative functions by court. While PIL has been partly institutionalized, it remains dependent on personal orientation of individual judges as well. So, in judicial activism, it still remains a challenge for the judiciary to strike a balance between allowing legitimate PILs and discouraging frivolous ones. Therefore, time and again it has been recommended preventive measures like building an economic incentive and confining PILs primarily to cases where access to justice is undermined by some kind of disability should be adopted. With this synoptic overview of judicial activism in India, I end my session and leave you with few questions which you will find very easy. Thank you for watching this video.